Okay, we are going to proceed on page 151, commercial law, and study the missing and ambiguous terms. The rules just stated make up the conditions for negotiability, dealing with two additional details: missing terms or ambiguous terms. Completes the picture. Notwithstanding the presence of regionally available form instruments, sometimes people leave words out or draw up confusing documents. Incompleteness. An incomplete instrument, one that is missing an essential element like the due date or amount, can be signed before being completed if the contents at the time of signing show that the maker or drawer intends it to become a negotiable instrument, unless the date of an instrument is required to determine when it is payable. An undated instrument can still be negotiable. Ambiguity, when it is unclear whether the instrument is a note or draft. The holder may treat it as either handwritten terms control typewritten, and printed terms, and typewritten terms control printed terms. Words control figures unless the words themselves are ambiguous, in which case the figures control. If the instrument contains a conspicuous statement, however, expressed to the effect that the promise or order is not negotiable. Conspicuous statement as well, to the effect that the promise or order is not negotiable. Its negotiability is destroyed except for checks, and an instrument may be a check even though it is described on its face by another term such as money order. Okay, we are going to proceed on section number 6, transfer and negotiations for commercial paper. Transfer and negotiation of commercial paper. Transfer means physical delivery of any instrument, to deliver it to another person, negotiable or not, intending to pass title. An instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving to the person receiving delivery the right to enforce the instrument. Negotiation and holder. Negotiation defines as a transfer of possession, whether voluntary or involuntary, of an instrument to a person who thereby becomes its holder if possession is obtained from a person other than the issuer of the instrument. A holder, though, is defined as a person who is in possession of an instrument drawn, issued, or endorsed to him, or his order to bear, or in blank. In blank means that no endorsement is required for negotiation. The original issuing of making of an instrument is not negotiation, though a holder can be the beneficiary of either a transfer or a negotiation. A person can become holder of an instrument when the instrument is issued to that person, or the status of holder can arise as the result of an event that occurs after issuance. Negotiation is the term used in Article 3 to describe this post-issuance event. Normally, Negotiations occurs as the result of a voluntary transfer of possession of an instrument by a holder to another person who becomes the holder as a result of the transfer. Negotiation always requires a change in position of the instrument, because nobody can be a holder without possessing the instrument, either directly or through an agent. But in some cases the transfer of position is involuntary, and in some cases the person transferring possession is not a holder. For example, if an instrument payable to bearer and it is stolen by thief or is found by finder, thief or finder becomes the holder of the instrument when possession is obtained. In this case, there is an involuntary transfer of possession that results in negotiation to thief or finder. In other words, to qualify as a holder, a person must possess an instrument that turns to her. An instrument runs to her. An instrument runs to a person if 1. It has been issued to her. Number 2. It has been transferred to her by negotiation. Negotiation is the post-issuance event cited in the comment. Liability of transferors. Liability of transferors. A brief introduction to liability will help in understanding the types of endorsements discussed in this chapter. There are 2 types of liability affecting transferors: contract liability, according to a contract between the 2 parties, and warranty liability. Contract liability: persons who sign the instrument, that is, makers, acceptors, drawers, endorsers, have signed a contract and are subject to contract liabilities. Drafts, checks, and notes are, after all, contracts. Makers and acceptors are primary parties and are unconditionally liable to pay the instrument. Drawers and endorsers are secondary parties and are conditionally liable. The conditions creating liability is that presentment, dishonor, and notice, liability, and discharge. Warranty liability, the second kind of liabilities. The transfer's contract liability is limited in this type. It applies only to those who sign, and only if certain additional conditions are met, and, as will be discussed, can even be disclaimed. Consequently, a holder who are not being paid often must resort to a suit based on one of 5 warranties. These warranties are implied by law. A person who transfers an instrument for consideration warrants all of the following to the transferee, and if the transferor is by endorsement, to be subsequent transferee. Number 1. The warrantor is a person entitled to enforce the instrument. Number 2. All signatures on the instrument are authentic and authorized. 3. The instrument has not been altered. Number 4. The instrument is not subject to a defense or claim in requirement in recoupment of any party which can be asserted against the warrantor. Number 5, the warrantor has been has no knowledge of any insolvency proceeding commenced with respect to the maker or acceptor, or in the case of an unaccepted draft, the drawer. Breach of one of these warranties must be proven at a trial if there is no general contract liability. Liability of transferors. Liability of transferees. The transferee takes by assignment as an assignee the new owner of the instrument has only those rights held by the assigner. Claims that could be asserted by third parties against the assigner can be asserted against the assignee. A negotiable instrument can be transferred in this sense without being negotiated. A payee, for example, might fail to meet all the requirements of negotiation. In that event, the instrument might wind up being merely transferred, assigned. When all requirements of negotiability and negotiation have been met, the buyer is a holder and may, if a holder, in due course collect on the instrument without having to prove anything more. But if the instrument was not properly negotiated, the purchaser is at most a transferee and cannot collect if defenses are available, even if the paper itself is negotiable.